Hello and welcome to Module 3 for Introduction to Law. And this module looks at both legal thinking and critical thinking. Legal thinking being specifically the mode of thought the legal profession lawmakers use. Critical thinking is a much broader concept, and that is a style of thinking that's evidence-based, that draws on credible evidence, tests that evidence, and supports reasoning with that evidence. So legal thinking is a form of critical thinking, needs to be a form of critical thinking, but critical thinking has broader applications everywhere. And both approaches are really fundamentally problem-solving exercises, the same way that solving a plumbing problem is a problem-solving exercise, solving a computer coding program is a problem-solving exercise. And these tools that we use to solve these problems are adapted and evolved to be used in a certain set of circumstances. So problem-solving legal tools are good at solving legal problems, and quite often they're not so great at solving non-legal problems. It's a bit like, using the plumber's wrench to try and solve the computer programming problem, although it's probably usually pretty tempting when you hit an impasse. It's the wrong tool for the job. So law is good at solving problems that involve legal concepts like rights and property and legal relationships. It's not so good at solving broader social issues. And we see that in some of the difficulties involving things like cyberbullying and hate crime, and areas where we're trying to create new definitions of harm or new definitions of control that don't necessarily involve old models of legal rights and legal relationships. So sometimes when we say, well, the law is lagging far behind, it's not solving the problem of the rise of Nazis again. Sometimes it's because law is just not the right tool for the job, and quite often it's a convenient tool for politics to be able to say, we'll just push that off to law. Law can solve all the problems we have. But it's the same as saying it's a plumbing issue or it's a computer programming issue. If it's not an issue that fits in that domain, then you're not using the right tools for the job, so you're not going to get a good solution. And that I guess leads us on to a couple of things. One is that the links between evidence and problem solving, and the other is what is law and why is it different. So just briefly, we've mentioned the idea of evidence previously. Of course, we don't just mean evidence as, blood splatters and gunshot wounds and that sort of legal evidence, but we're talking about the credible empirical data, knowledge, proof that you use to sustain a certain position. So evidence-based problem solving is important for all disciplines. It's been very important and very transformational, for instance, in medicine, where a lot of medical knowledge for a long while has been more received. We've always done it this way. This is the way we do it because that's what we've always done. And there was a revolution in the last couple of decades. And it's one of those strange things that you sort of assume that medicine is going to be a little bit more scientific than it actually is. But there was this sort of scientific revolution in medicine where medicine started saying, well, we shouldn't just do things because we've always done them. Let's start looking at the evidence base. So it's the same with any discipline or any area of study. You always end up with situations where people say, oh, this is the way we've always done it. And critical thinking is saying, well, what's the evidence? Is that the best way of doing it? It's not about just being negative and going, nah, I don't like that, I don't like that, I don't like that. It's about finding the justification. And in most problems, you'll have multiple solutions, and you need to be able to weigh those up and justify the one that you go with. More on that later. The next thing we wanted to mention was the difference between fact and law, and this will come up again and again. You'll see references to questions of fact and questions of law, and our legal system divides those in certain ways, and one of the most obvious ways in which is who gets to decide what are the facts and what are the law in trial. And juries usually decide the facts. Did this happen? Was this the case? And the judges decide the law, what those things mean in a legal sense. So it's almost as though when we talk about the facts, that's physical reality. Okay, and what the law is about the way the law interprets or perceives that, and think of that as a layer sitting on top of the facts. It's an interpretive layer, that's almost like augmented reality. You go out and you use Pokemon Go and you see the world out there, and you look at Pokemon Go and you see the Pokemon as well. If you had a law Go, you'd be able to see all the legal relationships and all the legal connections and the legal meanings of various things, as well as that physical reality. So a punch is just a punch, it's a physical fact, but it becomes an assault when it's legally defined as an assault. A piece of land is a physical reality, but in law it's interpreted as a piece of property. Two individual people, when viewed through the lens of law, will be viewed in different legal relationships. Maybe they're married, maybe there's a contract between them, maybe one person has a duty of care over another. So the difference between fact and law is that layer of meaning, that legal meaning that's added to things. And sometimes those legal meanings aren't necessarily that close to what the factual relationships are. But law has this process by which it applies these labels and defines these things. Now, pragmatically, one of the big differences, as I said, was the division of jury and judge. It also means that most appeals, which means most of the cases that are examined in law school, most of the cases we look at full stop, are appeal cases on issues of law, not on fact. It's extremely, extremely unusual to get an appeal on facts because, generally speaking, the jury's verdict stands. And this is where the Pell case, which we looked at in Module 1, is extremely unusual and in some ways extremely alarming to a lot of legal scholars, because this is a very rare situation where suddenly the courts are saying, well, no, the juries are wrong as a matter of law. And our well-held belief that we always respect what the jury has to say, in this circumstance, we're not going to follow the jury. And as you saw in the article, some of the reasoning there was, at least when critically examined, not necessarily all that consistent. So in reality, most of what lawyers do in law school is look at the law, and most cases don't even really discuss the facts in very much depth, because when the appeals occur, it's not on whether someone did something or not. It's about the legal interpretation of what that means and how that connects to the previous body of accepted law. Okay, so you'll see more of that. You'll see more of that in the study guide for this week. You'll also move on to discussion of how to locate the law in cases and legislation. And those of you who are law students, you'll find that we emphasize a lot of case law in legal study, but in reality, most law is done by legislation. It's one of those paradoxes of legal education. We have to teach you about the law through the cases, and in reality, it's the legislation that usually does the heavy lifting. And that's led to certain judges and certain critics, including Justice Michael Kirby, arguing that law school should really not look at cases much at all and should really be all about legislation. So more on that later. But this week we're just concerned with how, when you're looking at cases, you're looking at legislation, how you identify what parts of it are really about legal meanings and what are about decisions of fact. The next section looks at case notes. Making case notes is a very important skill, and you might say, well, why don't we just go to the head note, or why don't we just go to what the textbook says about a case? And in the purpose of study, that's often the case, that there is enough in the widely accepted synopsis of the case and what it says that it's true. But why we encourage you and often require you to do things like case notes is to get into the weeds of what a case is actually about. Why is this? Is it just because we're sadistic and we want you to do the hard work and not take the easy route and just look at what the textbook has to say? Well, this is because cases don't have simple meanings. The nature of the common law is that it's always changing, and usually when it changes, it involves a situation where everyone accepted what the head note had to say, everyone accepted what the textbook had to say, and then some bright spark went and read the case closely and went, you know what? doesn't actually say what everyone thinks it does. And that's where you get sites of legal change. And there are plenty of examples. The creation of negligence law was years and years of judges saying there's no such thing as negligence law, there's no such thing as negligence law. And then there was a closer reading of those cases where they said, well, actually, maybe there is. And suddenly negligence law was invented. And more recently in Australia, we've had a discussion of privacy law, and there was a standing case, a Victoria Park racing case from a mid-20th century that for years people said there's no tort of privacy in Australia. And then someone closely read the case, and the case wasn't really about privacy, it was about something else. And we've had several cases that have gone to courts of appeal in the state courts that have recognised a right to privacy. So if someone hadn't done a proper case note on the Victoria Park racing, and they just gone to the textbook and have said, oh yeah, there's no tort of privacy in Australia, Victoria Park racing, that would never have happened. So this is why we encourage you to get into that in-depth understanding of cases. So there's some guides as to how to go about that process. For me, the purpose of a case note is to identify the zones of disagreement, to find the areas where what looks like a simple proposition, actually when you unpack it, there's potential for disagreement, there's different opinions, and that's where you build these different ideas, where you say, Judge A said this, Judge B said this, there's uncertainty there. And my argument is we'll go with Judge A for these reasons based on this evidence. And I don't think we should follow Judge B because of these reasons on this evidence. So the practice of doing a case note, it's not a static thing. It's not a case of just recording dead history. It's about unpacking those principles and understanding them. We also have a section this week on doing an IRAC, which is a simplified case note, and that's really your trainer wheels to get you started, especially for the law students. Criminology students won't get much deeper into this, but the important thing to remember with IRAC case notes is they are very simple. They're training wheels, and at some point you'll have to take the training wheels off. And I know I've seen second year students who've said, you'll pry my IRAC from my cold dead hands, but it becomes at some point self-limiting because it is such a simple way of breaking a case down. So I'm just flagging that now. It is training wheels. It's a good way to start doing that breakdown, but please don't get committed to it to the point where you're limiting your ability to appreciate and understand cases. And finally, coming back to critical thinking for a moment, it's important to see critical thinking as part of a broader spectrum that all professions tie into, not just law. It's part of that notion of evidence-based reasoning. And a lot of it is about, the purpose of research, full stop, is to displace common sense understanding and reasoning. The classic one in science was that the sun went around the earth because we saw the sun go up and go down. Therefore, it must have gone down around the earth. We know that it doesn't because of scientific investigation, and that process was, the critical analysis and critical thinking around those accepted ideas. A more recent one I've encountered is some emerging evidence around trauma that suggests to us that, it shows pretty strongly that teenagers suffer much, much more from trauma than young children. And that's kind of inverse of what you often think. If you thought about who's going to suffer worse, a very small child or a teenager, you'd think the small child would suffer more. But we've got emerging evidence that small children tend to be more resilient for various reasons. And teenagers are really the risk point where they're exposed to violence and exposed to harm. And that really relates to the other subject that I teach, which is the understanding violence and conflict subject. But I think it's a good example of you can be a well-meaning person and you could say we've got resources to deploy to protect underage people, children, from violence. We've got to make a decision. Are we going to focus on the small children or the teenagers? Intuitively, most of us would go, oh no, let's go for the little kids. They're going to suffer the most. Research is saying, no, the point of intervention you really need to make is those teenagers. So I think that's a good example for me of critical thinking in the justice area. So in law, what does it mean? It means rigorously testing your authorities, both for the legal validity of those, is it following the correct authority, and also for the logic. And we'll go back to that Pell article briefly again to say that was a good example of someone who tested the foundations and said, look, these are the law and this is the established law and these are other jurisdictions, and said, I'm not really sure about how firm the chain of legal authority is here. And then in the more elaborate later part of the article, which was admittedly much more difficult to understand for a layperson and for, even for established people, actually took on the internal logic of the decision and actually said, well, the decision's not logical on these bases. So whether you agree or not with that particular article, I think it provides a good example to look back on with a little bit of time to reflect and thinking about the way in which critical thinking is so important to law and so important to be able to test those things. So moving on to the challenge for this week. This challenge applies the concept of critical thinking, and it does it by applying it in a different context. And we do that quite a lot with these challenges. We take a very, very complex situation and we reframe it in something that's simpler, that we can develop those basic skills that we can then apply in the more complex situations. So critical thinking, it's important to realize it's not just an individual thing. It's part of an individual's relationship with a community. So in the academic community, it's a researcher's relationship with other researchers, with the whole body of knowledge that's come before. And critical thinking is taking that body of knowledge and saying, what parts do I agree with, what parts do I disagree with, and why? And then synthesizing that into your own research. In the legal community, it's about the authorities, and it's about, like, we've got a whole series of legal authorities. If something is clear-cut and the authorities are very clear, it usually doesn't go much further. Okay, it doesn't go to court because no one is going to spend money on a court action that has no chance of success. But court actions occur and appeals occur specifically where there is some uncertainty in the law. And again, the case's relationship to the rest of the law is one where you're saying, well, this agrees with me, this one disagrees with me. I want to go with this one for these reasons, but I also need to critique that other position, and I need to be able to say why I'm not following that other one. So your ideas have this networked relationship to all these other ideas, and the process of critical thinking is about going through the process of weighing, evaluating, explaining, discussing, coming to a conclusion, explaining your logic and your evidence for coming to that conclusion. So this challenge cuts the vast scope of academic research and legal authorities down to the idea of a small village, and a small village of people who all have different opinions on a particular issue where a lot of land is to be deployed. And as a decision maker in that field, you need to respond to those different opinions and weigh up and balance those before coming to a decision. And it's important to say here that it's not an issue of majoritarianism. It's not about what the most people think is the answer you come to. And this is a problem we often face with discussions over politics. Is there's this idea that democracy is the same as mob rule, that if 99 people hate the one person, then the 99 people should have their own way. That's not how democracy works. Democracy is about representation to make sure that the one is protected from the 99. And the 99 from the 1 if required. So what you might be tempted to do with this problem is to say, oh, well, we'll just go with what most people want and that'll keep everyone happy. That's not how critical thinking works. How critical thinking works is you find the right decision, you find the reasons that you think are the strongest reasons and explain them as evidence, and the ones that are different opinions, you explain why you're not following that position. Even if it's what the majority wants, quite often the role of government in a democracy is to represent everyone and not to let the mob overrule the smaller groups. And yeah, I'm particularly frustrated when I see that all the time when people say most people want this, therefore that's what democracy should be, and it's not what democracy is about. And that's why we have laws and systems of rights to balance out that dangerous power of mobs. And not last year, this year we've seen what mobs can do. Mobs are not a great foundation of political action. And this does lead me to another point. Is so what do you do with dissenters? What do you do with people who disagree? And one of the temptations for beginning students is often just to pretend they're not there, that they're really inconvenient, and just, whether it be a piece of research that doesn't agree with you, or a different legal authority that doesn't quite fit with your scheme, you go, I'll pretend I didn't see it and don't include it, and you think, oh, that makes my case stronger. That's actually not true. You actually get more credit for presenting something that disagrees with you and explaining why that doesn't apply. And that's very important as a beginning student, to have that confidence to take things on and to say, okay, my conclusion on this paper is going to be this, and there's an opinion that doesn't fit in with that, but what am I going to do with that, and how am I going to use my evidence-based critical thinking to explain that? And that's what you'll have to do in this workshop too. There'll be positions that disagree, and you're going to need to make, as a group of people, a judgment on the basis of having everyone heard, making sure you canvass the range of opinions, but still making an actual decision on the evidence. So I hope you find that entertaining and interesting, and definitely easier than throwing a whole lot of legal authorities at you and having you navigate them in week 3 of the course. And as I said, this is one of these little skills that are the building blocks that build you onto the larger skills. Before we finish, I want to quickly mention the check-ins from week 2. There wasn't anything big that came up in there. Most of the issues people are having are just the teething troubles of, moving into a new discipline, using new databases and so on. No one seems to be struggling too badly. And the answer for most of these issues is patience and practice. The only way you get better is to be patient, to learn from mistakes you make, but also to practice those skills, and not just to say, well, I've read the book. That's enough. I'll somehow absorb it because I've read it, and I'm no doubt remember it, and that's all I need to do. Actually practicing it and doing it is how you remember it, and that's why we have those step-by-step explanations in the videos, and then the tasks for you to do. And we have some good feedback from people on the videos, so that's nice to hear that people found those videos very useful. So yeah, not a lot to report on the check-in this week. Things seem to be going along well. And that's it for the video, and I will see you in class.